All right, today we're diving into something that's like the secret weapon for every lawyer, the legal memorandum. We're going to break down the ultimate blueprint for taking a super complex legal mess and turning it into clear, solid advice.
So, picture this. You've got a client, a really tricky legal problem, and this massive jungle of laws and old cases. How in the world do you even start to figure out the right way to go? Where's the map?
Well, it's definitely not some big eureka moment. Nope. The answer is built step by step with some serious, clear-headed analysis. You need a solid framework, a system really, for thinking, for researching, and for laying it all out.
And that tool? That's the legal memorandum. Seriously, it's so much more than just a piece of paper. Think of it as the engine that powers the entire legal strategy. It's what gives the team the clarity they desperately need to give good advice.
Okay, so what is this thing exactly? Basically, a legal memo is an internal document. It's usually written for a senior lawyer, and its main job is to be totally objective, like brutally honest. It lays out all the research and analysis on how the law applies to your client-specific problem, and that means pointing out the good, the bad, and the ugly, the strengths and the weaknesses of the case.
Yeah, this quote really hits the nail on the head. I mean, the advice you end up giving a client, it's built entirely on the foundation of what's inside this memo. If you mess this part up, the whole strategy can just fall apart. The stakes are super high.
So how do you actually build one of these? Well, just like any good blueprint, you've got to start with a rock-solid foundation. And in the world of legal memos, that means getting your facts and your legal issues absolutely perfect.
Here it is, the classic structure. You've got 5 main parts. You kick things off with the facts and legal issues to set the scene. Then you give a brief answer right at the top, kind of like a spoiler for where you're going to end up. The real heavy lifting happens in the discussion, and then you wrap it all up with the conclusion. For today, we're going to zero in on those 3 big pillars: the foundation, the analysis, and that final conclusion.
Okay, first things first, the facts. Now, this isn't just you telling the client's story. No. Think of it more like you're a detective laying out all the evidence. It has to be a strategic, totally objective presentation of every single detail that matters for the legal analysis you're about to do. Getting the facts right takes some serious discipline. And the #1 rule, you can see it right here, is objectivity. You absolutely have to include the facts that don't look so good for your side, not just the helpful ones. Remember, your job at this stage isn't to be a cheerleader, it's to be a realist. All right, once you've got all your facts on the table, it's time to boil them down into sharp, precise legal questions. This is where you really define the core problems that the rest of the memo is going to tackle. And framing these as neutral questions is key. You're not trying to lead the witness here. Each question you write becomes a roadmap, right? A signpost that guides all of your research and gives a clear structure to the big analysis part, the discussion section. Okay, now we're heading into the heart of the memo, the discussion section. This is what I like to call the engine room. It's where all the action happens, where you dig into the law and connect it back to the facts you've already laid out. And where do you start? You might think it's with old court cases, but actually no. You start with the written law itself, the statutes, the regulations, anything that directly governs the situation.
And this is a really crucial point. The order matters. You always look at the legislation first. Why? Because all that case law, the decisions from judges, a lot of the time, they're just interpreting those exact statutes. It just makes sense, right? You start with the main rule, then see how it's been applied.
Okay, after you've got the legislation down, then you bring in the case law. This is where you go hunting for examples of how courts have dealt with this stuff before, especially in situations that look a lot like your clients'.
And when you find a case that's a close match, lawyers have a fancy word for it, analogous, you've got to dissect it. Don't just say who won. That's not the point. The real treasure is in the why, the court's reasoning. That's where you'll find the golden nuggets, the legal principles you can use for your own situation.
All right, this is the final and honestly the most critical step inside the engine room. You've looked at the statutes, you've looked at the case law, now it's time to put it all together and apply it directly to your client's situation.
This is where you truly build your argument. It's all about connecting the dots. You have to show exactly how those legal principles you found fit with the facts of your case. It's this act of bringing it all together, that synthesis, that makes the memo so incredibly valuable.
Phew. After all that intense work in the discussion section, you've got to wrap it up. You need to bring it all home with a conclusion that's clear, to the point, and tells the reader what's likely to happen.
And hey, the conclusion is not the place to introduce any new ideas or arguments. Look at this checklist. Your job here is simple. Directly answer the legal questions you asked at the beginning and give a realistic prediction of what you think will happen, and it has to be based only on the analysis you've already done.
Oh, and one more thing you can't forget, the table of authorities. You have to back up every single thing you say. This isn't just a bibliography, it's your proof. It's the paper trail that shows every source you used and proves that your research is solid.
So, you think you're done? Not quite. The heavy analysis might be over, but there's one last, crucial step. You've got to do a serious quality check to make sure this thing is professional, polished, and as close to perfect as you can get it.
This final check, it's absolutely non-negotiable. Just look at this list. Every single one of these points comes down to one thing: your credibility. A silly typo, a bad citation, an old case, any of those can just torpedo all of your brilliant work. Your great analysis deserves a flawless presentation, period.
And there it is, the complete blueprint for a killer legal memorandum. It's your tool for analysis, your roadmap for strategy, and the very foundation for giving solid legal advice. So now you've got the plans. The question is, what are you going to build first?